Happy Tuesday. It's time for coffee and cursey words. Yay. I have my coffee. I also have my cursey words. I also have my I Love Cursey Words shirt because I love this shirt. And we have a story that more is like in pacer as I'm talking. So we're going to get to that. It might take a little bit because there are more documents than I anticipated because stuff keeps getting filed. And that is the Jay-Z Rockefeller Records Damon Dash case. We're also going to talk about the NCAA and the Supreme Court and lots of time for questions, which means if I had one more story I wanted to get to. If we don't get to it, it's going to just keep getting bumped because tomorrow Britney Spears is in court and I'm dying. Let me know where you all are coming from. If you're drinking your coffee, if it's a cold brew or not, and we're gonna get into it. We've got a lot. We got a lot today. So let's just do the things. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see where everybody's coming in from. Good morning, good morning, good morning. It's sunny and bright here this morning. It was rainy and wild last night, so I love seeing it. Hello, Bulgaria. Hello, California. Hello to all the Canadian law nerds. I have to talk about Canada for a minute. We have to talk about Canada. Oh, Canada. So Michael, who is a friend of the channel and mod when he is not swamped at work, sent me a bunch of Canadian candy. And one of them, hold on, I've got to pull it up and make sure I get it right because I took a picture because I'm trying to find it. Our local grocery store carries like Brit Cadbury candy. And so my son is now obsessed. And now the family's obsessed. So let me pull up my photos because I didn't want to forget, and I would. The crunchy, the crunchy bar from Canada, this one, obsessed with this candy bar. And so we are just, our local grocery store, I think, has them. So we are just so excited. They are so good. The Cadbury US does not have nearly as good of candy as Cadbury around the world. It's just not as good. US Cadbury is just, it's not as good. We've got some others and they're great. We have Crunchies here too. They're unreal. See, Crunchies in Ireland. I love it. The Cadbury chocolates here just aren't as good. We don't even have Flake. Flake is amazing. So it's just, the candy here is not as good. We have coffee crisps in the cupboard. So that's what it is. That's what it is. Hello from Toronto. Welcome to your first live. Publix has an amazing selection of international foods, better than any of the grocery stores I found in Los Angeles, which really surprises me that Tennessee has more international foods than LA does. Like shooketh. Even the Costco. So everybody's like, yeah, US Cadbury is trash. It is. I lived in South Africa until I was 8, so I grew up with Flake, Crunchy, and Arrows. The Arrows are so good. They have those at our local grocery store. I keep them in my desk drawer because I don't want my kids to eat them. Flake is one of my favorite things ever. Cadbury makes enough money off the eggs they don't need to try, but that's bullshit because there's so many good candies out there that we just don't get. Ugh. Crunchies are so good. Anyway, so that is my hot take for the morning. Hello from Las Vegas. Hello, everybody. Hello, Teresa. When my mom was a kid living in extreme Northwest Minnesota, she would walk across the border without a passport to buy Kit Kats. I love that. And, it used to be that by land, if you lived right in the Canada-US border, you could just kind of traverse back and forth. So anyway, not to tangent about chocolate this morning before we get into lawsuits. but also to tangent about chocolate this morning before we get into lawsuits. Have you been watching the news breaking about the NC2A, y'all? Have you been following what the Supremes are up to? Also, I see a number of you that are like, it's your first live. If it is your first time catching a live in the chat, just put a 1 in the chat so we can see who's in new. And so all the law nerds can say hello and send you love for coming in live. Hello from Facebook and from Columbus, Ohio. The chat is much more poppin' on YouTube for all of you on Facebook that are like, why is she talking about all this chat? There's a lot more poppin' on the YouTubes. Look at y'all. Are y'all pulling my leg? We have so many. I mean, we have over 1,000 law nerds in here. We have so many of you coming in for the first time. This is incredible. Welcome, 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 welcome. So here's what we do. We say hello. Well, we didn't say hi to the replay crew. Replay crew, hi. Love you. Thanks for being here. We'll be timestamped down below at the end of this stream so you can find the topics that you're interested in, because we love the replay crew. Not everybody can watch live. I get it, especially on a Tuesday. So I trying to say hi to everybody who's coming in new, all the law nerds welcoming you. It's so good to see you. If you are new to the channel, don't forget to subscribe. World Market does have a lot of international chocolates. If you're looking for better chocolates in the US, the NC2A is losing their grip, which is probably okay. Do we have any NC2A athletes in the chat or parents of NC2A athletes in the chat? Let me know, because I cannot wait to hear your take. I was a NC2A athlete. I talk about this tomorrow a bit in the podcast that will be out for audio. The video is going to come out a little bit later because tomorrow Britney Spears is in court. Britney Spears is in court tomorrow, y'all. I have no chill. I have my Britney shirt ready to go. I'm going to wash my hair tonight so it's down. I am ready for Britney to talk to the court tomorrow afternoon. And if shit pops off, we'll do a live. The mods are like, this is the first we're hearing of it. Yeah, we'll talk about it. We'll talk about it for sure. So, let me just... This is a great question. Hello from Southern Australia. What is the NC2A? This is the first time I've heard anyone call it the NC2A and not the NCAA. I don't know. And I call it the NC2A, not the NCAA. The NCAA, I forget what the acronym stands for. The National Collegiate Athletic Association is the governing body for college sports. You know, the footballs, the basketballs, and everything else, tennis, gymnastics, running, all the things. So the NC2A is the governing body that makes all the rules about how much money you can make or actually not make if you are a college athlete, keeping college athletes amateurs. But, you know, college institutions make millions and millions of dollars off of some of these sports. I'm going to tell you what right now, this is going to be shocking to you all. Hold on, just take a breath. We're going to shock everyone. I sometimes say shocking stuff. I know Twitter's going to tell me about it later. Women's water polo, not making millions of dollars for universities. So the NC2A doesn't really give a fuck. But I know that that's shocking to you, that women's athletics do not pull in the money that, you know, a March Madness or, you know, football and the Rose Bowl do. I know. Hard truths here on the channel. Hard truths here on the channel today. So let's pull up the articles. There were a couple. The AP had a really good article about this. The Supreme Court, what the Supreme Court did yesterday is said, hey, you aren't above the law, NC2A. So I feel like we're in the middle of like a plot from Ballers. I feel like I'm waiting for The Rock to come out and be like, see, we can give the kid a car. Like, I'm just waiting. I'm waiting. I know you all are shooketh. Shooketh. My brother was also an NC2A athlete, a better one than I was. And a national champion. Look, I was a regional champion. We won Easterns. It happened. But also, y'all, I'm barely 5'7". And water polo. Look, I have like T-Rex arms. They're very short. Water polo, I loved so much, but I was not the best. I was good enough to play Division One. I was not the greatest. That is for sure. But I did get an inside look at the women's athletics and at the way that different athletes were treated. So let's talk about what the Supremes did with the NC2A and kind of schooling them over the way that they're not paying athletes. There is a long history of the NC2A having issues. Jenny, I was also a band nerd, but then I had to focus, and I focused on water polo. But band was so much fun. I loved band. I really did. And because I grew up in Southern California, a lot of members of the band got to be in like the Rose Parade and do like extreme marching band and shit. And I don't think, will somebody let me know, cheer parents? I think cheer is exempt from the NC2A, or at least it is. I mean, junior college doesn't count because it's not Division One. So I think there is definitely some room for cheerleading. And we're starting to see, especially like the cheerleaders from cheer being student athlete influencers. I'm not going to say cheer's not athletics. I just think they're outside of the NC2A. But we're starting to see student athlete influencers in other arenas. And I think we're going to see that after the Supreme Court ruled here. I think we're going to see student athlete influencers. So the Supreme Court ruled unanimously Monday that the NC2A can't limit education-related benefits. Here's my pondering. At what point is it's like, well, Johnny is that, Johnny Football Hero, because from the Not a Surf Song pop. Anyway, Johnny goes to USC, and Johnny can't live on campus because there's roaches. And Johnny needs an apartment in the hills. But then Johnny has to get to school. So if Johnny needs to get to school, then doesn't Johnny need a car? And if Johnny needs a car to get to school, isn't it an educationally related expense? Because, nobody walks in LA. Walking in LA. So nobody walks in LA. So Johnny needs a car. So I can see schools trying it with what the education related benefits are. This, I believe, intends for, books to be covered, which can already be covered by scholarship, computers, internships, fellowships, and other things. So let's dive a little bit deeper into this. I just think people are going to try it for fucking sure. USC, I'm going to pick on USC forever. Trojans in the chat, it's not you. It's just the institution as a whole. I had to grow up with the really annoying USC people. It's not y'all. The law nerds aren't, those USC people. But USC did get in trouble for this a number of years back because the money. So with regard to that, education-related benefits like computers and paid internships that colleges can offer their sports stars, a victory for athletes that could help open the door to further erasing in the decades-old fight over paying student athletes. And this has been an issue for student athletes for literally decades, because schools can get in trouble, athletes can get in trouble for getting paid, but also student athletes can't work. They need to support themselves like in the summer. Not all of them come from wealthy families, and you shouldn't have to come from a wealthy family to rise in athleticism. So this might give some opportunities for students to actually, do more than just surviving. And it's not the bigger sports that I'm so worried about. It actually can allow like the crew kids to maybe get a computer, the ones who aren't having their spots taken by some actresses' children that didn't actually do crew in the first place. Olivia Jade. Schools recruiting top athletes can now offer tens of thousands of dollars in education-related benefits that also include study abroad programs, graduate scholarships, etc. However, the case doesn't decide whether students can simply be paid salaries for the benefits of their efforts bring to measured in tens of millions for many universities. The High Court agreed with the lower court's determination that the NCAA limits on education-related benefit that colleges offer athletes who play Division I basketball and football violate antitrust laws. Whoop, there it is. What you can't do is price fix the student athletes. Nowhere else would you get a whole bunch of colleges together and say, you can only pay your professors this, so that there's no competition in bringing a professor to a certain school. If you don't think there is competition for, professors that actually bring prestige to the university, I've got something to tell you. There is competition, but imagine all the schools being like, well, that's not fair. It's not fair that Yale and Harvard can afford these professors, but that my school can't. So like URI is like, what? We're not Yale and Harvard. We can't compete for professors. So we're just going to price fix the whole thing. Whether University of Rhode Island actually has an athletic program, I don't know. All I remember is going to the college fair with my bestie, Chris, in high school and thinking that URI sounded an awful lot like UTI, and we giggled the entire time because I already knew I was going to school to play water polo somewhere that would accept me. So let's get back into this after that wandering tangent. There's going to be a lot of tangents on this topic. Just, it's what you're here for anyway. Hello, Rhode Island. This case is important in the short term for students who may see schools competing for talent by sweetening their offers with a variety of education-related benefits. Again, I see this for like the tennis kids who want to go to med school. I can absolutely see, amazing, Lucinda. I can absolutely see the benefit of kids in other sports. I think in football and basketball and even baseball, you have people with a lot of aspirations towards professional sports. In women's water polo, it's like, you don't have a lot of aspirations towards professional sport. There isn't professional sport. There is the Olympics, and that's about it. So I could see for most sports, the benefit of, hey, if you want to go to law school and you come here to play this sport, we can give you a 50% scholarship towards law school. I can see that being a huge benefit for student athletes, and perhaps allowing student athletes to be paid will keep good student athletes in college sports instead of being like, whatever, I'm a sophomore, I'm bouncing to the pros, and leaving college sports so that they can actually go and get that bag. So I think that it's a good thing for college athletics. I find that the NCAA is whining that this will make it harder for some schools to compete. It might. Schools are going to lean on their donors. But if they have a good football team, I think their donors are going to be here for it. For the international crew, I talked about it at the top that the NCAA, the National Collegiate Athletic Association, regulates student athletes, and the fact that student athletes have to be amateurs and cannot get paid. So you can't have benefits. You can't pay for a car, apartment, things like that. Kids can get full scholarships, including meals and room and board in the dorms, not in apartments, and things like that. But you can't pay for an apartment off campus. Sometimes you can't even go to dinner and have a dinner paid for. That was always a consideration. Like if your friend's parents wanted to take you out for dinner, is it a problem? And you had to be mindful of those things. Now, that's, not such a huge issue in sports like, well, anything that's not football, baseball, and basketball. I don't know. Is gymnastics, are people like throwing cash at gymnasts to get them to their school? I don't know. But the thought is, if you allow athletes to be paid, you have schools with larger donor pools going, okay, well, I can put $1 million towards the football program to get the entire football team the brand new, iPhone and new computers every fall. So that's what we're doing. So if you come play football here, new computer, new iPhone, new whatever, and we're going to have somebody drive you around campus in the, football team's golf cart. So you don't have to actually worry about even walking to practice. So this is opening the door for schools to bring other benefits. For huge money-making sports, I think it will allow kids to probably get some benefits for graduate work. And I think that that's a really good thing because, Look, being a student athlete it's kind of fun, but also it's a lot of fucking work. It's a lot of work. We had our own dining hall. The athlete dining hall did not have the good chicken fried steak. This probably tells you why I was not the world's best college athlete, because I ate easy cheese and chicken fried steak, habits that should have stopped when I was in my 20s. But then I moved to the South where they have Cracker Barrels and chicken fried steak is still something that's on the menu. Either way, they didn't have that at the athletic dining hall. It was way boring. So I didn't always eat at the student athlete dining hall because I wanted the honest, real talk, chicken fried steak and ice cream sandwiches. Oh, and the really good waffles. The waffles at the athletic dining hall weren't quite as good. I'm sure UMass stepped up its game from now. But this is going to open a lot of doors that the NCAA is going to have to figure out what their new regulations are, because schools are going to be doing everything that they can. So let's keep going. It's important in the long term because it sets the stage for future challenges to the NCAA rules limiting athlete compensation. This Supreme Court opinion was like, hey, athletes, bring in the lawsuits. Bring in the lawsuits about likeness. Bring in the lawsuits about all the things. We'll talk about name, image, and likeness in a minute. Justice Gorsuch wrote for the court that the NCAA sought immunity from the normal operation of antitrust laws, an argument the court rejected. His Honor said that allowing colleges and universities to offer enhanced education-related benefits may encourage scholastic achievement and allow student athletes a measure of compensation more consistent with the value they bring to their schools. They absolutely bring value to their schools. Huge value. The alumna and the boosters come to these schools for the football a lot of times and for the basketball. So let's see. I didn't know this either. Aki, I think. I hope I pronounced that right. I didn't know UMass had an athletic dining hall. They may not anymore, but they are number one nationally in dining 4 to 5 years running now, makes up for the terrible football team. The Minutemen are a terrible football team. The basketball team was always a lot of fun. I spent a lot of time watching rugby. I enjoyed rugby when I was at UMass quite a lot, when I was not at the pool. And the women's pool, by the way, was way jankier than the men's pool. Just saying. So I don't know if they still have an athletic dining hall. They may not. The NCAA defended its rules as necessary to preserve the amateur nature of college sports, preventing the blurring of the line between them and professional teams. I mean, come on now. They're younger, but they're run like professional teams. A lot of these student athletes go on to be professionals. The reason people watch it is because they're great games and because it brings the atmosphere of supporting your school. With colleges trying to lure talented athletes by offering over-the-top benefits, a lower court had upheld the NCAA's limits on scholarships and cash awards, and the high court wasn't asked to weigh in on those. So limits on scholarships and cash awards are still limited. The high court didn't talk about it yet. Same. Writing for only himself, Justice Kavanaugh signaled where Monday's decision may lead. He said there are, quote, serious questions. Yes, Judge Kavanaugh, we have questions. It's a lawyerly thing. I have questions. There are serious questions about whether the NCAA's other restrictions on compensating athletes can stand. So this is the judge literally signaling to the lawyers, bring on the lawsuits. I have questions about whether this other shit is illegal or not. Like, that's not before the court, but it seems that it could be. And it seems to the other judges, hey, judges, this shit may all be illegal, so let's take a look at it. Kavanaugh wrote that, quote, traditions alone cannot justify the NCAA's decision to build a massive money-raising enterprise on the backs of student athletes who are not fairly compensated. Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. The NCAA is not above the law, wrote Kavanaugh, who is a college who as a college student played on Yale's junior varsity team. I'm sure the benefits to being part of Yale's junior varsity basketball team were not outstanding, but I believe Judge Kavanaugh also went to Yale. We talked about that when we talked about the Tiger Mom Yale Law School drama. This case was brought by former athletes, including West Virginia football player, is it Sean or is it Shawnee? I don't know. Alston. It followed a separate earlier lawsuit brought by athletes, including former UCLA basketball player Ed O'Bannon and NBA legends Oscar Robertson and Bill Russell, where an appeals court concluded NCAA rules aren't exempt from antitrust law. This case ended with the Supreme Court declining to weigh in that case. As a result of Monday's ruling, the NCAA itself can't bar schools from offering Division I basketball and football players additional education-related benefits. And that's going to extend to other sports as well, because you can't treat them differently. You can't be like, okay, well, the NCAA can't limit it to other programs. The schools can limit it and be like, look, your program doesn't bring in literally any money. So the money's going to get distributed by who brings in the money. It's our hope that this victory in the battle for college athletes' rights will carry on a wave of justice, uplifting further aspects of athletic compensation, said Steve Berman, an attorney for the former college athletes, in a statement following their ruling. This is the fair treatment college athletes deserve. It also opens up some of the images with name, image, likeness, which I'm going to get into more in the podcast episode. Name, image, likeness is why EA Sports stopped offering collegiate football as a game, because they had the student athletes' names on the back of the football jerseys and their rough likeness. You can't do that without compensating them. And the NCAA is like, you can't compensate them, so you can't use their name, image, and likeness. This opens the door, I think, for college athlete influencers potentially to get paid by third parties and more. I'm going to link the actual ruling from the Supreme Court if you guys want to read the Supremes. They always use such small font. I know it's like a whole thing, but the opinions are always, even in the law books, always with the small font, always at the small font. But this, we can go through the ruling if you would like, but the article really sums it up well, that this is the antitrust case, which, you get into the Sherman Act, and it really lays out how they decided. And then we get into Kavanaugh's concurrence down here. There's the opinion of the court on the different parts. Where is the down at the bottom. We're only 33 pages in. The reason it takes so many pages is because you use like none of a page. I'm sure there's a reason. I am not a Supreme Court expert by any means. I'm sure there's a reason for the way that they do it. That's affirmed. Here is the concurrence. Just stating a little bit that the NCAA has long restricted the compensation and benefits that student athletes may receive. And with surprising success, the NCAA has long shielded its compensation rules from ordinary antitrust scrutiny. Today, however, the court holds that the NCAA has violated the antitrust laws. The court's decision marks an important and overdue course correction, and I join the court's excellent opinion in full. A course correction is really that, hey, you're not above the law, NCAA. But this case involves only a narrow subset of the NCAA's compensation rules, namely the rules restricting the education-related benefits that student athletes may receive, such as post-eligibility scholarships. That means after they are student athletes, scholarships for continuing education, scholarships for postgraduate work, and the like. At the graduate or vocational schools, the rest of the NCAA's compensation rules are not at issue here and therefore remain on the books. I think that's a very strong indication that other lawsuits should and will follow. Those remaining compensation rules generally restrict student athletes from receiving compensation or benefits from their colleges for playing sports, and those rules have also historically restricted student athletes from receiving money from endorsement deals and the like. Rise, student athlete influencer, because you can totally see student athlete influencers being compensated for protein or physiotapes or being on Instagram, and none of these rules applied then, but you can see the value in it, especially after watching the popularity of something like cheer. So first, the court does not address the legality of the NC2A's remaining compensation rules. As the court says, the student athletes did not renew their across-the-board challenge to the NC2A's compensation restrictions. Accordingly, we do not pass on the rules that remain in place. The court can only address what's before it. So this is the court saying, this is all that's before us, but if you bring something else before us, we'll happily consider it, without, of course, prejudging the facts. This is just literally a shot across the bow. Second, the court does not weigh in on the ultimate legality of the remaining compensation rules. Third, there are serious questions whether the NC2A's remaining compensation rules can pass muster under ordinary rule of reason scrutiny. Under the rule of reason, the NC2A must supply a legally valid pre-competitive justification for its remaining compensation rules. As I see it, however, the NC2A may lack such justification. I'm not saying I'm saying it, but I'm saying it. The NC2A acknowledges that it controls the market for college athletes. It concedes that its compensation rules set the price of student athlete labor at a below market rate. No shit. And the NC2A recognizes that the student athletes currently have no meaningful ability to negotiate. No, you play or you don't. The NC2A meaninglessly asserts that its compensation rules are pro-competitive because those rules help define the product of college sports. Specifically, the NC2A says that colleges may decline to pay student athletes because the defining feature of college sports, according to them, is that student athletes are not paid. That's not the defining feature of college sports. People like college sports because they enjoy the anything can happen. They enjoy the pureness of the sport, but student athletes being compensated, I don't think takes away from that. This goes on to talk about other cases and says that the bottom line is that the NC2A and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars of revenue for colleges every year. Those enormous sums of money flow to seemingly everyone except the college athletes. Word. College presidents, athletic directors, coaches, conference commissioners, and NC2A executives take in 6- and 7-figure salaries. Colleges build lavish new facilities, but the student athletes who generate the revenues, many of whom are African American and from lower income backgrounds, end up with little or nothing, which makes it really hard to get a leg up and start generating wealth that can sustain you if you are not receiving any pay for those 4 years that you put your body on the line. There's no guarantee that you won't get hurt before you finish your college career. Everyone agrees that the NC2A can require student athletes to be enrolled students in good standing, but the NC2A's business model of using unpaid student athletes to generate billions of dollars in revenue for the colleges raises serious questions under the antitrust laws. Word. And it goes on and on and on. So I'm going to link this for y'all if you want to read the entire ruling of the Supremes. If you want a deeper dive into why and how the Supremes ruled, we can. But antitrust, I mean, it's an antitrust case. The antitrust indicates that you can't price fix, and this is essentially price fixing of the labor of student athletes, and the judges aren't having it. So, hello, Rich Lux. Good to see you in the chat. Thank you for the super chat. Teresa, would you look at the Juilliard case? Students were protesting tuition increases. Security locked them in. Oh dear, violating the fire code, and now has suspended them and blocked them from rehearsal facilities. Oh my. I mean, if there is a lawsuit, I'm sure I will find it. I will take a look for sure. All right. Student athletes. We're going to get into the student athlete questions. If you guys have questions about the Supreme Court in a minute, let's hop on. Are you guys ready to talk about Jay-Z? Jay-Z, you ready? Are you ready? There's 2 lawsuits. I think I'm going to start with the smaller one the faster one first, and then get into the other one because they're both going to involve intellectual property. There are two Jay-Z lawsuits. So let's get into the first one. Let's get into the Jay-Z lawsuits. Hopefully you can't hear the fan on my computer heating up. I don't know why it's getting so sassy. So let's pull this up. This comes to us from TMZ. I swear TMZ, because Harvey Levin is an attorney, gets the scoop on these things. This is from 6/15/21. I hadn't seen it reported then. I saw it when I went looking for the newer lawsuit that had shit pop off today. But this is regarding a photographer. And that is very interesting to me. We talk about it with regard to who owns the copyright of images. Jay-Z is suing Reasonable Doubt album cover photographer. You're exploiting my name and image. We just talked about name, image, and likeness, and the rights to name, image, and likeness. So this was an update on what day was the 15th? I don't know. Last week. So many ads on TMZ. I need to put an ad blocker on my Google so that we can't see them all. I don't stand by the ads that pop up on the ad blocker. I need to ad block. So a rep for Marion tells us Mr. Marion has created iconic images of Mr. Carter over the years and is proud that those images have helped to define the artist that Jay-Z is today. Oh, the photographer has defined the artist that Jay-Z is today. Interesting statement to give to the news. Mr. Manion, we're going to go with Manion. I think I said Marion. Sorry. Manion has the utmost respect for Mr. Carter and his body of work and expects that Carter would similarly respect the rights of artists and creators who have helped him achieve the heights to which he has ascended. We are confident that the First Amendment protects his rights to sell fine art prints of his copyrighted works and will review the complaint and respond in due course. I don't have the complaint on this one yet, but I will suss it out and bring it up. Turns out Jay-Z can knock the hustle, or at least that's what he's trying to, because he claims in a new lawsuit that the photographer who shot his debut album is making tons of dough off the rapper's back. The music mogul is suing Jonathan Manion and his company, Jonathan Manion Photographer LLC, claiming Manion is exploiting Jay-Z's name and image without the rapper's consent. In documents obtained by TMZ, I swear lawyers are just emailing TMZ documents being like, did you see what we did? Did you see what we did? My emails are also open. If you want to tell me about somebody that you're suing or suing on behalf of, I'm here for it. I will always take a heads up. And we will talk about it for way longer than TMZ. Just saying, no shade to TMZ. They always have the lawsuit stuff, though. In documents obtained by TMZ, Jay says Manion has Hava's name and likeness plastered all over his website and sells photos of Jay-Z for thousands of dollars. This is the cover of Reasonable Doubt. It is an iconic image. Problem is, Jay-Z says he never gave Manion permission to do so, and he claims when he asked Manion to quit using his image, the photog demanded tens of millions of dollars. Millions of dollars. Tens of millions of dollars. Jay claims Manion is making an arrogant assumption that because he took those photographs, he can do with them as he pleases. Well, actually, copyright law. So the thing is, when you create it's going to be very interesting how copyright law plays with this. And this album came out, well, we're going to get into that in the article, but did Manion get an image release from Jay-Z? Did Jay-Z get a work for hire release saying that the image was made for hire and therefore Jay-Z owns the copyright? Who owns the copyright of this image is going to be actually really interesting and more in depth than just like, oh, well, Jay-Z's in the picture. Obviously, Jay-Z owns the picture. Not necessarily the case. Jay claims Manion is making an arrogant assumption that because he took the photographs, he can do with them as he pleases. If he owns the copyright, that might be true. Jay hired Manion in 1996 to shoot the cover for Reasonable Doubt. Jay says Manion took hundreds of pics, and Rockefeller Records used some of the photos for his album covers and paid him handsomely for those uses. The way that this is worded makes my lawyer brain go, oh, they licensed the photos. They paid him handsomely for those uses. So they licensed those photos, which means they might not own the photos. Photos might still be owned by the photographer, because if they license the right to use the image on the album art, it indicates to me that they don't own it because they didn't do a work for hire release. Jay-Z claims Mannion continues to prominently display Jay's image on the landing page of his website where he sells Jay-Z pics and merch. We're going to go look in a minute. Jay says he has strict control over whether and how his name, likeness, identity, and persona are used. Yeah, so did Ice Cube. And the court looked at Mr. Cube and went, it's a newsletter. They can use it. Also, when you are a public figure, there is some difference in that, particularly if somebody owns the copyright to these images. And Mannion never got the green light to continue hawking the pictures. Jay claims it's ironic that a photographer would treat the image of a formerly unknown Black teenager, now wildly successful, as a piece of property to be squeezed for every dollar it can produce. It stops today. I'm sure that's very strong language from the complaint. The rapper's suing to put a stop to Mannion selling the pictures stat and wants him to fork over the profits he's made off his likeness. Oh, we'll see how long that goes. It said they reached out and so far no word back. And then they got word back, it looks like at 3:30, saying that, hey, I am an artist. I created the art. Let's go look at his website real quick. I haven't pulled that up yet. I'm very, very curious. So let's go look. The things you should Google before. Oh, of course I can't find his photo website because the news stories are bumping it down. Okay. This, I believe, is his website. So let's see if, I don't know if pictures of, there we go. There's Jay. So I was going to say, I wonder if pictures of Jay-Z and Aaliyah and Drake. All right, let's see. Let's see what's in the store and BMWs. All right. Let's see what you can buy. Has he been sued over the Aaliyah prints yet? I wonder. I have questions. Let's see what else. Contact sheets, Sunday edition print, slip mats, Biggie. I mean, are we only selling photos of the deceased? I want to see what else they're selling. This, however, is that's a gorgeous photo. Just saying. All right, your girl's going to get distracted. That's a gorgeous photo too. I didn't know he took, this one's also iconic. I don't know which album this was from, but that is an iconic DMX photo. Let's see who else is on here. It looks like the Jay-Z stuff is down. Let's see what the merch says. DMX merch, which are all Where My Dog's At. Fame wall. Interesting. I wonder if these are the photos he's taken. I imagine that these are the photos that he's taken. It's weird that he calls it the fame wall. But anyway, Jay-Z, Eminem, DMX, Aaliyah, Biggie, Mos Def, Lauryn Hill, Snoop Dogg, Outkast, and Nas. What else is in the merch shop? The camera with his name and a diamond. Okay. No comment. Photography since 1993. These are the old logos that are escaping me, but I will think of it because when I used to do photography and develop film and developers, it's a whole thing. Collection is empty. Well, I was curious. What else is empty? Let's see what the Sunday edition prints and the special edition prints are, because I don't see any prints of other than this one. All right, $1,500 for this one. That is not the photo from the album cover because that one was probably purchased or licensed. Let's see. What else? I think that's all of them. So one of Jay-Z that's up. That's interesting to me. I thought that there would be more. I wonder if he took them down when the lawsuit hit. So we're going to pull up the lawsuit. That's a fantastic picture. I like that Eminem was the like bite your lip and look sexy meme from TikTok before there was the bite your lip and look sexy meme on TikTok. Eminem's like, I actually really enjoy some of these photos. I'm so glad we Googled this. Aren't we glad we Googled this? This is a gorgeous photo of Lauryn Hill. Look at that. Look at that. That's stunning. Anyway, I'm going to stop complimenting the photography. It's going to be an interesting conversation. Look at Missy. It's going to be an interesting conversation about who owns the copyright. And I think this will have implications for copyright law. And I think getting the court to cleanly rule on what this contract said is going to be very, very interesting. My son, by the way, gets called Travis Scott all the time. And he's like, stop it. Something about Travis Scott being on Fortnite and then it becoming a thing. So some striking photographs here, but who owns the copyright? And very, very often the copyright is owned by the person who takes the image, and there are generally image releases. If there aren't image releases, then there might be some disparity, but we're going to have to see. We're going to have to see if there were image releases, if there were just licensing. The TMZ article uses very interesting language. We're just going to have to pull the lawsuit and look at the language and see what happens. I'm going to keep up on this lawsuit because I'm actually really interested to see how they parse the difference between a celebrity who's very clearly a public person and their right to their name, image, and likeness, and the photographer who took the photo and their right to own the copyright in the photography. So that's what we are going to do. Okay. Should we get into the other lawsuit, the NFT lawsuit? I think we should. I'm going to just real quick, because we're 45 minutes in. If you have not liked and subscribed, do the things. I wonder if let me look on the back. Let me look and see if we are in Bing Bing territory, because I'm curious and I'll let you know, because I think we're close on binging at 132. We are close at binging at 132. So if you're not subscribed, even if you think you're subscribed, go ahead and do the subscribey and the thumbs uppy thing. And we'll see if we can bing. We'll see if we can bing while we're live, because that's always fun. It's always entertaining. And why are we, what did I say that we are already in the yellow on monetization? YouTube has gotten really feisty with live streams lately. It used to all be good, and now it's just feisty. All right, let me close a few tabs because my computer's also getting feisty, and talk about this NFT sale. More information just came out on this NFT sale this morning because the court granted a temporary restraining order, and we will pull up the declaration from Jay-Z, the court's declaration order, and all of it. We'll go through all of it together. I'm going to give a brief overview first. So let's get into that. Jay-Z's old business partner has 99 problems, and a lawsuit is one. God, it's a dad joke. I know it. 99 problems, and a lawsuit is one. So what are we suing over? Let's see. Let's pull up the article from yesterday before everything got updated from Rolling Stone. Rockefeller Records sues Dame Dash for allegedly trying to sell NFT of Jay-Z's Reasonable Doubt. Dash claims he wasn't trying to mint and sell the album as an NFT, but rather his stake in Rockefeller Records. So what is an NFT? An NFT is a non-fungible token. NFTs, this is not financial advice. NFTs are kind of a new wave of digital blockchain collectibles. So NFTs, if that's blinking on your end, I'm sorry, it's not blinking on my end. NFTs have become something that YouTubers are selling, other celebrities are selling. You're seeing NFTs of different types of digital art. I imagine we'll start seeing Disney selling collectible and limited NFTs of stills, animation stills and pre-animation work and stuff like that. It's going to be really fascinating. So what they're saying is, by attempting the sale, Dash has converted a corporate asset and has breached his fiduciary duties. His planned auction of Reasonable Doubt would result in irreparable harm, the lawsuit reads. We're going to just pull up the lawsuit in a minute because we have it. Wait, where's the rest of the article? See, I don't want to subscribe to Rolling Stone. I had it pulled up earlier and then it blocked me. Freaking paywall Rolling Stone, that's fine. I read the whole article earlier and then it paywalled me. I should have taken notes. Guess what? We're going to go back to TMZ. Screw you, Rolling Stone. TMZ broke the story anyway because I think the lawyers just emailed them. Rockefeller is knocking Damon Dash's hustle. The recording company is suing one of its own founders in a first of its kind lawsuit, claiming Dash is trying to auction off one of Jay-Z's debut albums as an NFT. This album is hot in the lawsuit world right now. The record company is going after Damon for allegedly trying to mint Reasonable Doubt as an NFT, non-fungible token, and auction it off to the highest bidder. A piece of hip-hop history, RAF says, is not Dame's to sell because the company owns it. According to the docs filed by Powerhouse attorney Alex Spiro's Adventures. I'm going to go with Spiro. Damon planned to sell the album as an NFT at a since canceled auction, but the company was worried DD would just try to find another platform to hold the auction. In the lawsuit, Rockefeller claims Damon is frantically scouting for another venue to make the sale. So let's go and look at what the lawsuit says. After we break this down, I will get to questions and then I will get to any of the super chats I missed. I saw a couple of them bing in, but I don't want to get distracted. I do want to pull up the complaint and then we're going to pull up the motion for a temporary restraining order like we saw in the Haley Page suit. We also saw it granted here. We also saw it in the Nike Satan shoes, but the Nike Satan shoes suit, they asked for the sale to be stopped, but the shit was already out of the horse and they couldn't stop the sale. Here, the NFT sale has not happened yet. And so it seems that they have been able to successfully block it. We'll get into the court's ruling in a few minutes. I say it like it's going to be fast. We'll get to the court's ruling in a bit. This is in the Southern District of New York, Rockefeller Records, Inc., the label versus Damon Dash. Nature of the case. We've got dramatic reading of the lawsuit. I feel like it's a whole genre. And the lawsuits are getting written with more and more sass. The lawsuits weren't this fun when I was in law school, mostly because a lot of them were by appellate judges. Lawsuits have gotten way more fun. The clock is ticking. Dash had planned to sell at a Super Farm Foundation online auction on June 23rd. What is that, tomorrow? Yep. On June 23rd, the copyright to Jay-Z's debut album, Reasonable Doubt, recognized as one of the greatest recordings in history. That auction was canceled, and Dash is currently frantically scouting for another venue to make the sale. It is not a matter of if, only when. But Dash does not even own Reasonable Doubt or its copyright, and therefore has no right to sell the album or any rights to it. Instead, RAF Inc. owns all rights to Reasonable Doubt. The sale of this irreplaceable asset must be stopped before it is too late, and Dash must be held accountable for his theft. I think it's attempted theft at this point. I feel like it's attempted theft at this point. But anyway, Sean Carter, aka Jay-Z, Kareem Burke, and Dash each own 1/3 shares of Rockefeller Inc. In 1995, Rockefeller and Jay-Z inked a record deal under which RAF would own, among other things, the masters and LP from the inception of the recording thereof, and all phonograph records and other reproductions made therefrom, together with the performances embodied therein, and all copyrights therein and thereto. I know. Music industry contracts. We're back to music industry contracts. Excluding the copyright in the underlying compositions throughout the world. This is because the copyright in the underlying compositions would be owned by the composer. And all, if you didn't watch me talk about this in regard to Mr. Kardashian, Kanye West himself, that was rude, Emily. Don't be rude. Mr. West. I actually like the way he took on the recording industry. So no need for sass, Emily. Check yourself before you wreck yourself or get sued by Ice Cube for saying that. Oof, it's going to be that kind of a day. Okay, here's the thing. When it comes to music copyright, there's a lot of layers of ownership. We've talked about this with regard to Taylor Swift too. You can own the rights in the lyrics, you can own the rights in the music composition, the rights in the music performance. You can own all the rights together, squished together into a song that's the master. There is a lot of different rights that go into the ownership and copyright of music. It is deeply complex. And when you add on top like streaming rights and rights to license to things like TikTok, the music industry has gotten very deeply complex. If any of you are in law school or thinking of going to law school, look, here's my best advice to anyone in law school. Take more classes on intellectual property, because the new wave of real estate is intellectual property. It is staking your ground on property that is not tangible. NFTs are not tangible, but they sell for very real amounts of money. Copyrights are rights in words and images and sometimes dances and compositions. Copyright and intellectual property is where you're going to see the battlegrounds in our court systems in years to come, and we're already seeing it now. The next year, pursuant to this agreement, Jay-Z released the album Reasonable Doubt, also legally related. The album was a huge success. It is frequently lauded as one of the greatest rap albums of all time, was certified platinum by the RIA of America, and has sold well over 1 million copies. I can't imagine it hasn't sold more than that. I want to know what the streams are on it too. After several decades, RAF Inc. remains the sole owner of the rights in Reasonable Doubt. So 3 people own RAF Inc. RAF Inc. owns the copyrights. One of the people who owns a third in the company is trying to sell his right, but you can't just sell your right in an ownership of a property as a fiduciary of the company. We're now pulling in vibes from like Toddy Westbrook, Clark Swanson, and where the fiduciary duty is in a business. We're pulling in the music industry. There's a lot of interesting pieces to this lawsuit already. During the past year, the market for NFTs, non-fungible tokens, has exploded. An NFT, oh, here we go. Here's a legal definition from the lawyers. Thanks for explaining it, lawyers. Let's see if we did better than me, probably. An NFT is a unit of data that is minted. It's blockchained, is what it is. It's blockchained. So it can be uniquely its own and can't be never duplicated. You know, they just NFT'd that YouTube video, Charlie Bit My Finger, for a fuck ton of money. Hold on. Tangent. And it came down off of YouTube, I think. Oh, Charlie. Let's see. But it's interesting because they NFT'd Charlie Bit My Finger, but like the kids own the video. It's so interesting because their likeness is in it. But let's see. Viral Charlie Bit My Video Finger set to stay on YouTube following NFT sale. It sold for $760,000. This is buying and selling the rights to viral videos. It was sold to 3F Music for over $760,000 as an NFT. A statement on the website charliebitme.com said the video was set to be deleted from YouTube. The video has over, where is it? It has like hundreds and hundreds. Oh, 884 million views. Like, leave that shit on YouTube till it gets to 1 billion views for sure. If you haven't seen Charlie Bit My Finger, you can still go watch it. But we're going to see the buying and selling of intellectual property through NFTs that are blockchain. So it's like, I can prove to you I own the copyright. I can sell my trademark rights in something as an NFT, and then you own it, and it's all blockchain together. It's fascinating, but it opens up this new market of buying and selling the intellectual property rights of goods. It's fascinating. That's the declaration. Where's the other one? An NFT is a unit of data that is minted and stored on a digital ledger blockchain. that certifies a digital asset to be unique and therefore not interchangeable. Simply put, it is a digital asset recorded on the blockchain that shows proof of ownership. NFTs can be created to transfer ownership of virtually any asset, from visual art to sporting event tickets to copyrights. NFTs can be freely bought and sold like any other asset. Some NFTs have traded for tens of millions of dollars. Go look at the NFTs if you're curious that Logan Paul was selling. You want to talk about get that bag. I think Ethan Klein also experimented with NFTs and other YouTubers. NFTs coming with like, here's an NFT and a ticket to a live event. Here's an NFT with this other benefit. NFTs are going to change the way fandom works. Let me tell you what, if the Dave Matthews Band is like, hey, we're selling these limited edition NFTs that also come with a ticket, I'm like, take my money. Take my money. Take my money. If Apple started selling NFTs in like the visual of some of their early day plans and stuff, I'd be like, I want to own the NFT for that. I don't want to own the patents for it, but I would love to own the art. I want to own shit. I want to feel cool. I don't own any NFTs. I'll keep you posted. We're going to find an NFT to buy that's cheap, and we're going to buy it just for fun on the, we should do that. Maybe for the members only stream. Superfarm owns an online platform that mints and sells NFTs to the public. Dash saw an opportunity in this emerging NFT market. The rights to reasonable doubt are highly valuable and unique. They can be used to create derivative works to generate significant financial and non-financial benefits. Well, I mean, it's only a third of the ownership. Anyway, there's only one reasonable doubt. The rights to it are irreplaceable. Dash knew this and sought to cash in by auctioning the copyright to reasonable doubt as an NFT. Though the original auction was canceled, it is believed that Dash has already minted the NFT, which he intends to sell through another auction or some other means as possible. So he's already blockchained it. But again, Dash does not own reasonable doubts. Jurisdiction and venue, yada, yada, New York. Factual allegation, Jay-Z's rise to fame. Are we doing a whole... Oh, yeah, we are. Okay, we're doing the whole thing. Everyone knows who Jay-Z is, but that wasn't always the case. It was only through exceptional vision, persistence, and hard work that Jay-Z has attained an extraordinary level of popularity and fame in the United States and around the world. Before Jay-Z has achieved this success, no one would give him a record contract. He got his start by selling CDs out of his car in the Brooklyn projects. Jay-Z's career took off in 1996 when he released Reasonable Doubt, which solidified his standing in the industry and has now achieved preeminent status. Its cover is recognized around the world, hence the photographer lawsuit. Jay-Z is now known as one of the most influential rappers of all times. He has sold over 50 million albums and 75 million singles. He's won 23 Grammy Awards. I didn't realize it was that many. The most by a rapper. He holds the record for the Billboard 200's number one albums by a solo artist with 14. He's ranked by Billboard and Rolling Stone as one of the 100 greatest artists of all time. In 2017, Jay-Z became the first rapper to be honored into the Songwriters Hall of Fame. In 2018, he received a commemorative Salute to Industry Icons award on this at the 60th Grammy Awards. And I love that we just get his resume in here, but the court needs to know what the value is, and this is establishing what the value is. In 2021, he was inducted to the Rock and Roll Hall of Fame. How did I miss that? Becoming the first living solo rapper to be inducted. Beyond his career as a performing artist and songwriter, Jay-Z has attained significant success as a businessman. In 1999, he founded the clothing retailer Rocawear. In 2003, he founded luxury sports bar chain 4040 Club. Both have become multi-million-dollar companies. Based on the success both in and out of the recording studio, Jay-Z has become one of the wealthiest Black Americans and wealthiest American musicians. Jay-Z also devotes a significant amount of time to philanthropic work. In 2003, Jay-Z, together with his mother, founded the Sean Carter Foundation to assist students facing socioeconomic hardship to get a degree. More recently, he donated significant amounts of money to persons arrested while protesting against police brutality. And in 2020, he donated $1 million through the foundation to combat the COVID-19 pandemic in New York. Then it gets into the ownership of Reasonable Doubt. It's owned by the record label. I don't think they can argue that it's owned by the record label. Dash holds no individual ownership in Reasonable Doubt, including its copyright. He owns it as a 1/3 owner of Rockefeller. I wonder if he's going to be like, fine, I'll NFT my 1/3 ownership in the label then, which is interesting. I wonder if it was minted just for reasonable doubt, which is what it says. Dash attempts to auction his purported interest in the copyright to reasonable doubt, a company asset. Dash is attempting to steal a company asset, mint it as an NFT, and auction it. Originally, he planned to use Superfam, an electronic platform. Dash's original illicit plan to auction his non-existent property interest in reasonable doubt is detailed in the auction announcement. Superfarm, I keep saying Superfam. Sorry, y'all. Superfarm is proud to announce in collaboration with Damon Dash the auction of Damon's ownership of the copyright of Jay-Z's first album, Reasonable Doubt. This marks a new milestone in the history of NFTs, entitling the new owner to future revenue generated by this unique asset. The monumental event will last for 2 days, starting on June 23rd, concluding on June 25th. Superfarm is excited to host a truly remarkable auction and immortalize one of the world's greatest artists on the blockchain. Selling the copyright to Jay-Z's Reasonable Doubt as an NFT is a groundbreaking landmark both for the crypto space and the broader music industry. The newly minted NFT will prove ownership of the album's copyright, transferring the rights to all future revenue generated by the album from Damon Dash to the auction winner. The whole process will occur on-chain thanks to the magic of Ethereum blockchain. Well, that's the blockchain that they're using. Ethereum is also a coin. We'll have to do a whole episode on blockchain. And Superfarm, innovative blockchain technology. The significance of this NFT cannot be overstated. They then get into more details about the auction. First claim, declaratory judgment against Dash. RAF repeats and incorporates above. They own all rights. So the declaratory judgment is, Your Honor, can you please tell this dude that he doesn't own this shit? Declare it. Declare. You don't own that shit. We own that shit. That's what they're looking for in a declaratory judgment, for the court to be like, okay, kids, you don't own this. This belongs to them. It's a company asset. Second claim, breach of fiduciary duty. What you can't do is go ahead and sell company assets. Shareholders in a closed corporation owe fiduciary duties to one another and the company, including the duty of loyalty. Accordingly, Dash owes a fiduciary duty of loyalty to RAF Inc. The duty of loyalty requires the best interests of the corporation and its shareholders take precedence. Third claim, conversion. We've talked about conversion so much. It's when you take somebody else's shit and try to make it into your own shit to do some shit with it. They're saying by stealing the copyright to reasonable doubt, minting it or planning to mint it, and offering it, he acted to exclude RAF and the other shareholders from the benefit of that asset. He's going to argue, I was only selling my part, and I'm allowed to sell my part. I can sell my part, but it's also going to depend on what the operating agreement of the corporation says, whether you're allowed to sell that or not. Replevin. Y'all, I don't even think we've gotten to Replevin yet. I don't think we've had a Replevin cause of action. Law students everywhere unite. Look, Replevin actually happens in the real world. Who would have thunk it? I don't even think I've seen a lawsuit with Replevin as a cause of action since law school. I am stoked. Let's read because I am amused deeply. RAF owns all property interest in reasonable doubt, including its copyright, and has the right to possess those interests. Dash has stolen and claims that he owns the copyright, but he knows that he has no individual ownership rights. They have demanded he return the property. He has refused. Dash is therefore unlawfully and in wrongful possession, so they want to get that shit back. It's ours. RAF has the possessory right of the property that is superior to Dash's interest, which is non-existent. So the Replevin is the give the shit back. Hold on. We're going to go to the dictionary definition of Replevin. It's been so long. We're going to the dictionary. Hold on. It's big. We're doing it. And then we're going to come up with the Lawnerd definition of Replevin. Yes, everyone needs one of these. Black's Law Dictionary. It's so girthy. Let's see. This was essentially what my life was like as a law student, was searching through Black's Law Dictionary for shit because it wasn't all aligned then. I could Google it, but that's not nearly as much fun. I want to see what Black's Law says about it. Yes, you probably already Googled it faster. I get it. Replevin. If y'all have your Black's Law Dictionary 7th edition, it's on page 1302. An action for the repossession of personal property wrongfully taken or detained by the defendant, whereby the plaintiff gives security for and holds the property until the court decides who owns it. A writ obtained from the court authorizing the retaking of personal property. It's repossessing shit. It's a writ of replevin. It's like, hey, you've minted this as an NFT. Give that shit back to us, and we're going to hold it until the court is done. So replevining, we're not going to get into all the different types of replevin, but that shit's mine. I'm going to hold on to it till the court decides because I don't trust you with it. So it's disengorging somebody of the rights to own it. Well, the court decides. Though there was no claim of action for replevin, it's essentially what happened to Haley Page's Instagram account. It got yeeted. Yoked. And given to her former employer, though they say they're still her employer. Anyway, unjust enrichment. You can't do that, and you would be unjustly enriched by doing that because you don't have the rights to do that. Prayer for relief, enjoining Dash from selling any interest in reasonable doubt, awarding RAF Inc. general and compensatory damages to be determined at trial, entering a judgment declaring the following. Declaratory relief. A, RAF owns all the rights to reasonable doubt, including its copyright. B, Dash, as an RAF shareholder, has no direct interest in reasonable doubt. C, Dash is not permitted to sell any interest in reasonable doubt. D, Dash must transfer RAF Inc. any NFT or other asset in his possession, custody, or control reflecting rights to reasonable doubt. Mom, make him give it back. Give it back, give it back, give it back. You don't own it. Tell him he doesn't own it. Mom. Nominal damages, punishment damages, prejudgment and post-judgment interest at a maximum rate allowable by law. Yeah, and we want interest. Costs of the suit and reasonable attorney's fees, other relief. Now, after this happened, they also filed a motion for a protective order. So in order to show cause to get the court to order that this sale could not happen. So I'm going to real quickly go over that. I'm not as interested in the motion for protective order because they laid it out in their lawsuit the same way Nike laid it out in the lawsuit that you could see this coming. But I'm going to pull up Jay-Z's declaration because I'm always curious in people's declarations to see what they have to say. But let's just get into this real quick. Lots of law. Business. The clock is ticking. Yeah, see, we've already covered this in the lawsuit. The sale of this irreparable asset must be stopped before it's too late. We know who Jay-Z is. During the past year, the market for NFTs has exploded. This is all in the lawsuit. Dash does not own reasonable doubt or the rights. We know this. It was in the lawsuit. There is no doubt that RAF will suffer irreparable harm because it's a unique asset. RAF is likely to prevail on the merits for declaratory relief, breach of duty, conversion, replevin, because they own it. Third, the balance of equities tips in RAF's favor because without a temporary restraining order, Dash will sell something he does not own, and then it's a big old mess to get it back. Finally, injunctive relief will serve the public interest because it will prevent Dash from deceptively and unlawfully auctioning off an asset he doesn't own. Can you imagine paying like millions of dollars for the copyrights in this and then having a court be like, yeah, by the way, you're going to be wrapped up in litigation forever because you can't own that. Statement of facts, most of which are mirroring what's already in the complaint that we read. Ownership, the company owns it. Proposed action, Dash is brazenly attempting to steal a company asset minted as an NFT and auction it off using an online platform. Bad Dash. All right, let's keep going. I joke, but actually what you can't do. So could he sell his interest in the company? And that would depend on what the company says. But what you can't do is sell off corporate assets that you don't own. You can't. And so even though it might feel like they have to act fast. They do have to act fast because if this gets sold, it's going to be a whole big mess. This goes through the legal standard of when you grant a preliminary injunction preserving the status quo. We know that the court's already granted it, so we're not going through the law here because it's a waste of everyone's time. The court's already been like, right, we agree. And it makes sense. There's no harm in pausing the auction. There is harm allowing it to go forward. This is why a permanent injunction until the end of trial was granted in the Haley Page case. Where is the harm? There's no harm in pausing it. There is harm in allowing it to go forward. The balance of equities is all done. Conclusion, the court should grant the request for temporary restraining order and preliminary injunction in its entirety. They've established that it will suffer irreparable harm absent the injunctive relief. And in this case, the sale hasn't already happened, like in the Nike Satan shoes, where the shit was already out of the horse and there was nothing the court could do about it to fix it anyway. So the court said, okay, well, don't sell the last pair of shoes. And the last pair of shoes didn't get sold. Do you want to see Jay-Z's declaration? Me too. Let's see Jay-Z's declaration and then we'll get to questions. All right. No, I had already pulled it. Emily, no, wrong button. Hit the right button. Declaration of Sean Carter, aka Jay-Z. I, Jay-Z, hereby declare that the following statements are true and correct. I am a shareholder of Rockefeller Records and respectfully submit this declaration based on my personal knowledge and review of the files of RAF Inc. in support of RAF Inc.'s request for a temporary restraining order and preliminary injunction dated June 18th, 2021. Yeah, like just a few days ago. RAF Inc. is a New York corporation that was incorporated June 8th, 1996 by Damon Dash, Kareem Burke, and I each own a third of the shares. Look, this is why you need lawyers when you create anything, because hopefully some of the operating agreements will be able to sort this out. RAF owns all the copyrights and titles and interest to and in my album Reasonable Doubt, including without limitation the right to sell, record, reproduce, broadcast, transmit, exhibit, distribute, advertise, and exploit the album. A true and correct copy of the contract. Oh, man. The contract is attached. See, I literally pulled this morning because it took me forever to find this lawsuit on Pacer. Dash holds no individual interest in Reasonable Doubt, including its copyright, and has no legal rights to sell it. I learned through a draft press release that Dash intended to mint as an NFT the rights, including copyright, to Reasonable Doubt and imminently sell NFT via auction with Superfarm Foundation. Superfarm, damn it. I'm going to keep messing that up. That was scheduled to commence on June 23rd. A true and correct hippity hoppity. It's a copy. A true and correct copy of Superfarm auction announcement is attached as Exhibit B. The album Reasonable Doubt is highly unique and irreplaceable asset. On June 18th, RAF Inc.'s counsel sent Superfarm a letter demanding that it cancel the auction and return the property. Yeah, I'm sure they did. I'm sure that was a strongly worded lawyer letter. Hey, what you're not going to do is go ahead and sell this shit. That's what's not happening. And we're going to sue to get it to stop. A true and correct copy of the letter is attached as Exhibit C. Oh, we get to see the letter. Well, we'll just get to it. On the same day, RAF's counsel sent a letter to Dash, who refused to comply, and it is believed is currently scouting another venue to make the sale as soon as possible. A true and correct copy of that letter is Exhibit D. Oh, I bet that's strongly worded too. RAF has not previously sought an order to show cause or temporary restraining order. I declare no penalty of perjury. Dated, signed. Let's get into the exhibits. The following how long is this? How long is this contract? We might need a contract breakdown on this. How long is this? 3. Why are we not loading? Oh my goodness. 4, 5. 6. I wonder if there's any updates to this contract or if this is just what it is. Let's see. It doesn't say streaming rights. I wonder if there's an update to it. Let's see. We'll get to the end and see if there's an update. 10, 11, 12. So this is the rights from Jay-Z to the company to sell the album. Can you see? You can see the hole punching because this is probably a physical typed out contract because of course it is, because October 1st, 1995. The term of the agreement shall commence on the date extending 10 months following the company's initial release. All references to the term shall refer to the period during the term of the agreement. The artist agrees to not record master recordings for any third parties. Oh, so there are re-record rights after the term. Interesting. But why would you do that? Because you own a third of the record label. The company shall pay the artist all recording costs set forth in the approved recording budget. Artist shall submit a recording budget to the company. The company shall have the right to approve or not approve. Artist shall be responsible for the payment of all recording costs or other costs in connection with making masters which costs have not been specifically approved. 100% of the recording costs shall be recoupable from any monies, excluding mechanical royalties payable to the artist. So the company's going to pay, the company pays the recording costs that they approve. The artist pays anything that goes above and beyond, but they take the cut of the costs off the royalties from the album before the royalties get distributed, much like lawyers on contingency. Lawyers on contingency win an award or a judgment. They take their they take their lawyer's fees first. They should take costs first, but they don't. Check your contracts. They generally take costs. They're cut first, then costs, then the rest gets distributed. So costs come out first. Delivery rights and recording. As between artist and company, all masters embodied in the LP and all masters hereunder shall be deemed works made for hire. This is the language I was talking about with the photograph. Works made for hire means that Jay-Z, if he's writing it, is making it for hire to Rockefeller, so they own the rights. Taylor Swift didn't do this in all of her albums. She still owns the copyrights in the lyrics that she wrote. This shows that Jay-Z does not own the lyrics and the masters. They're owned by Rockefeller, which he is a part owner in. So it comes back around. It just works a slightly different way. Name and likeness. We and any person, firm, or corporation designated by us shall have the perpetual worldwide right to use and to permit others to use your name, both legal and professional, approved likeness, approved biographical material concerning you for the purpose of trade promotion, advertising in connection with the LP. That's the likeness release part. This goes into the royalties. And what the royalty split is, if you guys are interested in that, we can come back and go through royalty splits another time. But this just accountings, copyright licenses, so they're all owned as they are. They're all owned by Rockefeller. And that is what that is. There's the definitions. Definition sections are super helpful. Master recording. Every recording of sound, whether or not coupled with a visual image by any method and on any substance or material, whether now or hereinafter known, which is used. Hereinafter known, by the way, is super helpful because the way that they were recording things in 1995 is not the way they're being recorded now. So they can end up in different formats, and this covers it, which is used or useful in recording production. Mechanical royalties are royalties payable to any person for the rights to reproduce and distribute copyrighted music. Side. Remember when there used to be an A side and a B side? A recording of sufficient playing time to constitute one side of a 7-inch 45 RPM disc phonograph record, but no less than 2.5 minutes of continuous sound embodying performance of artist. That's so funny. Single, a 7-inch 45 RPM phonograph record or equivalent embodying thereon at least one side, expressly including a compact disc or pre-recorded tape embodying the same two sides on each side A and side B. It's like an old tech alert, but old contract alert. All right, let's go to the sassy lawyer letters. Exhibit B. This is the release. We saw some of the release in the body of the lawsuit. Reasonable Doubt was Jay-Z's first album, created without any major labels or record deal in 1995, sold out of his car. Superfam announces NFT. It's just going to be. Superfarm announces NFT auction. Oh, we just need water. Y'all can read along. Jay-Z, hip hop. By the way, do we love this look? I was inspired. I had never seen this anywhere. I have a blue one that's hiding back there. That's blue and red. It looks kind of like a bomb pop, but the pink and purple it felt like a moment that needed to happen. All right, back to life, back to reality. So, how to participate in the Ethereum auction, have your wallet ready to bid, all the things. Exhibit C, sassy lawyer letter. Let's get into it. Via email and FedEx from June 18th to Superfam, to whom it may concern. Legal notice to cease upcoming auction. I write on behalf of Rockefeller Records, Inc. regarding information we have received concerning a super farm auction scheduled for June 23rd concerning Sean Carter, aka Jay-Z's album Reasonable Doubt. If you have legal counsel, please direct this letter to him or her. Specifically, as reflected in the attached announcement, we have learned that you and Damon Dash intend to auction an NFT reflecting ownership interest in the copyright of the album. Dash has no ownership interest in the copyright of the album. Instead, RAF owns all rights. In and to Reasonable Doubt, by attempting such sale, you and Dash have wrongfully converted RAF's property and violated their rights to this unique asset. Further, Jay-Z has the rights to use his name and likeness, among with other rights of publicity, which cannot be exploited in the commercial manner reflected in the marketing materials. This is different than the Ice Cube case where it was a newsletter. This is actually using Jay-Z's name to market the copyrights for sale, and which damages have already been sustained. I don't know if there's any damage just yet, but we'll see. You must therefore cancel the auction immediately, deliver all evidence to RAF Inc. related to the wrongful conduct, and transfer to RAF any and all property reflecting its ownership of Reasonable Doubt, including any NFTs you have minted in connection with the auction or otherwise. We request you complete and your compliance and confirmation by 5 p.m. today. Here's the stat, or we will be filing a lawsuit against you. Well, it looks like they complied because they did not get sued. Meanwhile, you are instructed to preserve all documents. There's the notice to preserve related to this dispute, including all electronically stored information and paper files you maintain. We request that you immediately cease any document deletion policies that may exist. Notice to preserve. See, some people will try to say, oh, it's my normal habit and practice that things get written over. This can happen legitimately or not legitimately. If you have a Ring camera that goes up to the cloud that writes over it whenever it gets a certain amount full, that is a normal practice of deletion. It overwrites the camera. This happens with security cameras at grocery stores and Target and whatever. Some of them rewrite like every 24 hours. So unless you preserve it and know that you have to put aside the deletion process with like, oh, our emails get deleted monthly or whatever it is, you have an exception to the right to preserve to anything that was like, well, that was an automatic process that was happening. We didn't intend to delete it. So it's very clearly delineating the right to preserve. Some will say, oh, I never, save a live video on Instagram. Therefore, I can't be required not to delete it. Some of those things are a little sus. They're very clear. They're very clear on the duty to preserve here and the notice to preserve. All of my clients' rights and remedies are preserved. Then they attach the like, hey, this you using Jay-Z's name out here to sell this thing? Let's see what the other letter says. It was not super sassy. It was just a you're going to get sued letter. What you're going to do is get sued. Legal notice to cease upcoming auction. Dear Michael, I write on behalf everybody's named Michael all the time. This is probably Dash's attorney. I'm writing on behalf of Rockefeller Records regarding information we have received concerning a super farm auction scheduled for June 23rd. Specifically reflected is the attached announcement. This is the same. By attempting such sale, Dash and Superfam Farm have wrongfully converted RAF's property. You must therefore take all necessary steps to cancel this auction immediately, deliver all evidence to RAF related to this wrongful conduct, and transfer to RAF any and all property reflecting its ownership of Reasonable Doubt. We request your complete compliance and confirmation by 5 p.m. Eastern Standard Time today. Fucking day. Or we will be filing a lawsuit against Mr. Dash. A lot of lawyers will attach the lawsuit. By the way, here's the lawsuit. They might not have had it done yet by the time they set this out because they were trying to stop the sale. Meanwhile, Dash is instructed to preserve all documents related to this dispute, including electronically stored information, and we request he immediately cease any document deletion policies, which his documents may be subject to. All of my client's rights are reserved. Here's the attachment. All right, last thing, and then questions. Let's see what the court said. Let's get to the court's ruling because the court has already ruled in this, which is so helpful. Why are you trying to? Don't log me out, Pacer. Where is the love? Where is the love, Pacer? I guess I have been talking for quite a while. I have been. All right, let's get to the court's ruling. Oh, we'll just pull it up instead of reading it off the small thing. We'll just pull it up right here. The judge. Here comes the judge. Wait, make it bigger. The court is in receipt of Plaintiff Rockefeller Record Inc.'s proposed order to show cause with emergency relief, docket 5, memorandum of law in support of plaintiff's proposed order, docket 6, and declaration of Jay-Z in support of plaintiff's proposed order, docket 7. Those are the ones we went over. Plaintiff requests an order to show cause, preliminary injunction, temporary restraining order. The court will hold a conference to address these requests on June 21st, yesterday, at 3 p.m. at the scheduled time with the calling code. That was not the order. That is not the page that I want. We need to download that. I want to save it. I don't want to have to pull it up again. There's the order. Wrong one. Here we go. Order to show cause. So the judge has redlined this. This was proposed by the party. So this was sent by Jay-Z's lawyers, and then the court redlined what they were doing. Upon the complaint dated on June 18th and the memorandum of law on the first day of July, order to show cause before motion of this court on the first day of July at 10 o'clock a.m. So they will be doing a hearing at 10 a.m. on this. Ordered that pending the determination of plaintiff's order to show cause, defendant and all those in active concert with him and all persons having notice of this order by personal service or otherwise be and the same hereby are restrained and enjoined from altering in any way, selling, assigning, pledging, encumbering, contracting with regard to, or in any way disposing of property, interest in reasonable doubt, including its copyright, and including through any means, such as by auctioning the NFT, reflecting those interests, significant reason appearing therefore. So that's the judge saying what you can't do is anything. We're going to have to hold a hearing. Stop right there. Thank you very much. So this is going to be a very interesting. I think this is the first lawsuit over NFTs. I tell you what, intellectual property is going to be hot. Oh, God. Feeling hot. All right. We're going to stop singing. We're going to get to questions. This is going to be very, very interesting. Are you guys fascinated? Are we fascinated by NFTs? I'm fascinated. I have questions. You have questions. I'm going to pull up any super chats that I missed. Thank you so much for super chatting. This is the first one that I see. So it is the one that is getting pulled up first, and I will go to others as I find them. Fascinating stuff. You guys put question in front of your questions. Don't forget to like and subscribe. Let's see if we can make it bing. We're pretty close according to the back end. We are very close. We are very close to making it bing. Very close. So over 2,000 of you here. If a few more of you subscribe, this should bing. If Jay-Z purchases licenses 20% of the total photos taken, does the photographer have unlimited use of the other 80%? I think yes, but the photographer is going to argue, well, no, Jay-Z is going to argue, hey, it's my image and likeness. And the photographer is going to be like, right, but I have copyrights in the image that I took. So that's where we're going to get whether there's an image and likeness release or not to use Jay-Z's image. So it's going to be very, very interesting. Brittany shared, I've made 10K in NFTs. It's been amazing. I mean, get it all. Get it. Kibby said, getting ready to leave for my move for Tennessee. Congratulations. I just noticed Emily and I are wearing the same shirt. Twinning. Congratulations on your move to Tennessee. You'll love it. We spent Father's Day out exploring east of us a bit. It was way less humid than right where we live. It was so lovely. We had so much fun. I'm still a little tired, but we had so much. I'm tired because I'm old. We had so much fun. All right, let me get to a few more super chats to make sure I didn't miss anything. I try my best. There's an artwork section in his contract. Does it have bearing on the photographer lawsuit? That would be a different contract. The artwork section in this contract, and but also Good Eyes, the artwork section in this contract is Jay-Z having his likeness sold or being used and licensing his likeness and image and stuff to Rockefeller Records. Now, between Jay-Z and Rockefeller and the photographer is going to be a different contract. Yes, Ashley Vincent, that's 100% it. Don't orders to not delete your shit. Notice to not delete your shit. All of the don't delete your shit. All of it. All of it. I missed a super chat that said the New York Times posted an article saying that Britney Spears quietly pushed for years to end her conservatorship. Well, I guess we'll see tomorrow. Let me pull up the back end and make sure I didn't miss anything else. You guys, I see some of you subscribing. A few more of you, and we will bing. Get it, get it, get it, get it. All right, this is pulling up. So I will look for what the New York Times had to say. We got to Kibby's. Jamie Bush, thank you for the super sticker. Blue Moon DRM, thank you for the super sticker. I think we're caught up. Thank you, thank you. Thank you, everybody, for the super chats. Much appreciated. Always appreciated. It lets us do fun stuff and giveaways. The giveaway winners have been contacted from the giveaway on Instagram, and so those will be announced on Instagram, and I'll put them on the community tab too. Question from Emily. Hello, Emily. Hello. Are you familiar with the podcast Watch What Crappens? They recap Bravo shows. I feel like you guys need some sort of a crossover. I have not. I will go look for it for sure. Welcome to Alive, Sean. I'm so glad you made it. Hi. Thank you, Jennifer. All right, I'm going to pull up and see if I can see some questions. Ooh, that was a lot, y'all. We went through a lot. Quick shout out. Love that the mods speak up as things start to look a bit messy and everyone stops, files out a Thunderdome in an orderly fashion and goes for coffee together. I love that. The mods, because when I don't see the chat and I'm getting through the stories, the mods help keep the value in our community and the values of our community, which are really making sure that it is a place for conversation. So I appreciate that so much. So thank you for the love to the mods. You guys, you cannot have a chat like this without fantastic moderators, and we have that, and I appreciate it so deeply, and I love that the law nerds appreciate it too. That's what we value here. Conversation, facts, not fuckery. On the subject of contracts and NFTs, those, if you're some kind of content creator, being clear about NFTs specifically would probably be a good idea. Yes, I had to adjust my contract for my clients. Yes, but this is something that wouldn't have been done in a contract in 1995. This is the new level of digital release. In the image releases I have written, I have always included like in whatever form throughout the universe. And people are like, it's like, you don't know when we're going to start selling NFTs with, the Martians. We don't know when we will start selling NFTs with other celestial beings. Who knows? Might as well put it all in the contract. Things you can't conceive of is super helpful. My throat is so dry, but we've got like all of the like purple and pink going on here today, which is fantastic. I'm just looking for questions and it takes me a minute. Question, what time is the Britney hearing tomorrow? Is it a Zoom call that anyone can call and listen in? It is not a Zoom call. You have to get approval by the court to call in. I don't know if they've closed that already because I did not look. It is at 1:30 PST tomorrow. I don't think it has been changed. I'm going to pull up the docket after this. I will keep you guys posted on social about the Britney hearing. And depending on what the court rules are, most courts say no contemporaneous sharing of information. So like no live tweeting, but I will see what the court's rules are and what I can share for sure. Kelly, question: if someone takes a photo video of me on the street and it goes viral, who owns the copyright? Could I control publication of my image? It depends on quite a lot of factors. Generally, the person who took the photo owns the rights, but they need a release of likeness so that they can not necessarily have it go viral, but sell it. It becomes very hard to get photos shut down if it's a newsworthy public place. If it is exploitative, then you have better and more rights. That's different if you are a private individual or a public person. So it depends on quite a lot of the circumstances. And I don't want to be instructive on that, but photographers have to be mindful of that if they are out and about somewhere where they are taking photos in a public area that faces either aren't recognizable, they aren't being sold, and things like that, unless it is public figures. Like if you are going to take photos at a concert or a rally or something like that. So it just depends. It just depends. Hopefully that answered it well, but the problem is some of this stuff is so deeply situational and so deeply fact specific that it's hard to give like a bright line black or white answer. Because generally the photographer owns the rights in the photograph and you own the rights in your images, and a photographer shouldn't sell that without an image release, but there are exceptions to that rule. Question: but if Jay-Z hired him with the purpose of shooting the album cover, doesn't that make it a work for hire? Esme, this is a fantastic question. It doesn't automatically make it a work for hire. The courts have ruled pretty consistently you need a work for hire release. A photographer can come take pictures of you, and those can still be the photographer's property. Even though they've sold you the images, they have not sold you the copyright unless it specifically says so. There was a lawsuit with regard to this and Obama's Hope poster that he used in his campaign. Because I'm just going to pull up the poster here. So this poster, iconic, famous, we all know it. We know exactly what this poster is. But this was taken from a photo that was taken by a photographer who was working for the AP. The thing is, they were working for an employer, so the employer owned the rights to the photo. The campaign did not get the rights to the photo. So street artist Shepard Fairey and the Associated Press are settling copyright dispute over who owns the rights to the iconic Obama Hope poster, the two said in a joint statement Wednesday. The out-of-court settlement ends the closely watched 2-year-old lawsuit without resolving the underlying legal issue, whether Fairey had a fair use right under copyright law. So we will go through this if you want to. Fairey had long claimed he based his abstract graphic rendition on a photo of Obama sitting next to actor George Clooney, but he later admitted he actually used a solo shot of Obama from the same event and had destroyed and fabricated evidence to support his story. So we will get into this lawsuit if you guys are interested, but there were quite a lot of copyright disputes over who owned the right to the image, because the image was owned by not the photographer who took it, but by the company they were working for. And it was either Getty or the AP at the time. So if you recreate a work of art from a photo, this is also going on with Kat Von D. If you recreate a work of art from a photo and it's not transformative, then it's not fair use and it is a copyright violation. And oh my God, do you see why intellectual property can be so deeply complex? It's like with Kat Von D. She tattooed a portrait. She tattooed a portrait of, was it Miles Davis? Yes. And the photographer was like, oh, what you're not going to do. So this is the portrait. This is her. I mean, she is we're not talking about the individual that is Kat Von D and all the wackadoodly shit that goes on with Kat Von D. But as an artist, this is a fantastic recreation, right, of this photograph. However, it is just a recreation. It's not transformative. The artist, the photographer, owns the right to this iconic image, not Kat Von D. So she is being sued over copyright infringement because the photographer said, that's my photograph. It's an iconic and stunning photograph. But what you can't do is then turn around and just directly recreate it on somebody. So if we are interested in the different types and the interplay, I will do an episode just kind of breaking down the photographer lawsuit and some of these other lawsuits to kind of give a juxtaposition of how this this comes about in context. Will, question, have you seen Earth 2.0 NFT virtual reality fiasco? No, I haven't. But now I'm very curious. But I have not seen the Earth 2.0. Is someone NFTing the globe? Who owns the rights to renderings of the Earth for virtual reality? That's very curious. Question, does Jay-Z have standing in the other suit if it's album artwork? This is a fantastic question, Katya, because the other lawsuit clearly says that he gave the rights to Rockefeller, but I haven't pulled the language yet because TMZ reports that Jay-Z is essentially suing Damon Dash, but it's really Rockefeller, and they say they interchange it. So without pulling the language of the lawsuit, Jay-Z might be suing in connection with Rockefeller, saying, I'm suing for my image and likeness because you're selling my image and likeness, and you can't sell my image and likeness. Rockefeller can, I can, but you can't. So I have to pull the other one. All right, I think I'm caught up. Question, how many till it bings? Oh, you're going to make me do math on the fly? Not very many. Not very many at all. Like, I don't know, 30 or something. We've got 2,000 people in here. You might all be subscribed. So if you're all subscribed, it's not going to bing. Did they mention how much they were trying to sell it for? I might have missed it. I didn't know. NFTs are an auction, kind of like eBay. So they didn't mention how much they're selling the NFT for. We saw that an NFT of an old YouTube video sold for what, $700,000? So Cindy said, never get to watch a live and I am homesick today. I thought I would, but I did not get my notification in time. Boo notifications. If you're not in the text crew, join because I send out notifications there. But I am live every Tuesday at 11 a.m. Central and every Friday at 7 p.m. Central. Jojo, do you think this could be a publicity stunt by Rockefeller to promote more listens and sales to his first album? I don't think this is a publicity stunt. I really do think this is Rockefeller trying to protect the copyright interest so they don't have to go through the expense of unwinding an NFT in the copyright. So I think this is actually a legitimate concern. You can't have a member of a corporation selling off corporate assets and copyrights that are very valuable and unique in NFT without permission. So I wonder what's going on behind the scenes with the relationship of the founders. I don't know what's going on with the relationship of the founders of Rockefeller, but Rockefeller, I keep saying feller, I try. So it indicates to me that there's other issues going on behind the scenes there, but this is a problem. Yes, Molly Jarvis, UMass. I talk about it in my TED Talk, I think. I transferred after I got injured to Cal State Long Beach. So I've gone to lots. Question, how do you think they can remove Dash? Oh, well, I don't know. It depends on what the operating agreement says for how they can remove co-owners of the corporation. So it's going to really depend on the way that that's written. I don't know if it's going to be as easy as 2/3 vote or that they're going to have to buy him out. I don't know. And I don't know if they want to. It'll be interesting to see, likewise, if the Westbrooks try to remove Clark Swanson from Halo Beauty and those companies. It'll be very interesting to see. Let's see. Question. Since the Supreme Court said the NCAA was being shady, can schools that were slapped down get money back or something? I don't know. Oh, my stream seems to be freezing a little bit. If I'm freezing, I'm sorry. It seems to be freezing on my end. I don't know if there would be grounds because the rules applied at the time. This isn't retroactive. This is going forward. So I don't know. I don't know if there's grounds to go back and say, hey, you were violating antitrust laws and we got in trouble because the rules were the rules at the time. So I just don't know. Thank you, mods, for letting me know that even though the video got out of sync, you can still hear me. I don't know what that's about. I need to ask my kid what he's streaming. That's probably what that's about. That's probably what that's about. Let's get to a few more questions and then we're going to get to court of public opinion. And Eminem sold a beat as an MFT. Buyer was rapper Tom McDonald, who used the beat in his song Dear Stan. I wonder how much he sold it for. I love that he's like, hey, you can sell the copyrights in that stuff easily. So Eminem's Stan Revenge MFT has been sold for a whopping $100,000, won by rapper Tom McDonald. And the thing about an NFT is Tom McDonald can use it and then go ahead and sell it, which is fascinating too. Question, can you cover colleges wanting to pay their athletes? I did, Judy, at the beginning. We talked all about the NCAA at the beginning of the stream. Question, no kitties today? Nope. I think they're probably upstairs with my son. He's back from camp and he is probably upstairs gaming and they're probably hanging out upstairs with him, which is good. He enjoys it. Question, for example, in wedding photography, can you buy back a set of photos? Does the photographer keep the copyright to all of them? Yes. And can they sell it later? If they have a release to sell it later, yes, they can, unless it's specific in your contract that it's work for hire. It's why if you hire a photographer for headshots, you need to make sure that those are being released to you so they can't go and sell them later when you become, TikTok famous or something. It's also the fact that I've seen entrepreneurs be like, oh, here's my headshot to put on your website because I'm a speaker at your upcoming conference. So you can use my headshot on your website, and seen websites get takedown notices being like, hey, that's my copyrighted photo. I didn't give you permission to use the photo. The entrepreneur bought the photo from me, but doesn't own the copyright. They can't give it to you to advertise your conference using their photo. People who don't understand these rights can end up unintentionally in a pickle where you've paid a photographer for things and not gotten everything. This happens with designers too. If you pay a designer to design a logo for you, if you don't own the copyrights in it, you can't go register it and protect it. They have to do it. Work for hire release. And if you're a photographer and you don't want to sell the copyrights to your images, then don't sell the copyright to your images and make it very clear that you're not selling it and get a likeness release. If you're a photographer or a creative and you're selling the copyrights, charge more for your shit because you're selling the rights to it down the road. Ariana Grande got in trouble for using Pop's photos on her Instagram. Right, because she didn't have the copyright to do that. Question, I need to know where your necklaces can be purchased. I love the layered look. Oh, Bob and Carrie Kennedy. Well, thank you so much. I added this one over the weekend. Not this one. I added this one over the weekend from Kendra Scott. I love a layered necklace too. This one is a Kendra. Now we're tangled. This like fish scaly one is a Kendra Scott necklace. This little one I just recently found when I was unpacking. I'm going to be very tangled now because of course. I bought this from a jeweler in the jewelry district in Southern California. It is just a little circle with pave diamonds. And then this one I bought for my 43rd birthday from Vuitton. So those are the three stacked together. High, low, medium of all the things. So this is a Vuitton logo with a diamond in it, though I think it looks very much like a Triforce, which is why I like it. This is Kendra Scott. It's probably on their website, and they actually sell some layered pieces. And then this is from a small jeweler in the jewelry district. So I love the layered look too. It's why I keep pulling my shirt down. I'm like, I've got to wear this with a different, some of my V-necks hit differently so you see them better. Amy, FYI, who owns the copyright in an image is different in the EU and UK. It is copyright saying what the subject of the image is a default. It is different depending on where you are. International law is definitely different. So, Melly Lynn says, so no snapshots of someone in court to keep a mental picture in your mind because it was just a mind shot, not really a snapshot. Exactly that. So Sierra, I'm always late too. It's good. Tara, my sister-in-law's wedding photo was up in the mall for years because he owned the picture, right? And photographers can sell those to like websites that then resell them to like a frame manufacturer to put it as the default image in a frame and stuff. It's very, very interesting. So Mariana says, I've been obsessed with photo release forms since I was in high school. I tend to yell, I do not sign a photo release form around cameras and public privacy is number one in my book, especially now with my babies. Totally understand. And it's why you'll sometimes see photo notices or filming notices that are like, you're going to be on camera, particularly if you're in like Los Angeles. If they're filming something, you'll see a notice and they have to get releases. Question. So would a situation like student pictures, would that be a work for hire situation? Not necessarily. And you also generally get photo releases for your kids at the beginning of the year. Like if you're taking pictures at a school event, I release the rights to my kid. And if you don't sign them, your kid will get blur-faced out of school photos. I saw one that just jumped and I was going to answer it. And then the chat was like, bloop. Question, are releases like that opt-in only? If I had someone take pictures in a casual setting and they later used it for commercial purposes, is that legally okay without a release from me? They generally need a likeness release, but if it's in a public setting, it can vary. I did not see Adam McIntyre. Oh, there we are. Hello, friend. Look, this photo of you and your cat just slay. It's good to see you. We're talking about photo releases and likeness and image releases. It's very fun. Olympic gymnasts were lured to UCLA's program, highly paid or compensated. They wouldn't have been because UCLA would have gotten in trouble. It might have been to work with the coach, and it might be that they can get paid now, but they wouldn't have then. Missy says we need an old school breakdown of copyrights and work for hire. Yep, I think so too. Ashley said, I wear the black diamond heart pendant that matches my engagement ring every day. And sometimes I also wear my relationship collar. I love that. I love black diamonds. I actually have champagne diamonds that when I don't wear these, I wear champagne diamonds. I'm also getting I want a new cuff that has like a chain. I've been scoping new ear jewelry. It's coming. I love Kendra Scott jewelry. I like that they donate proceeds. I like that they're easy to replace. I like that they just take care of you. I like it. Question, what can they do about the tattoo if she doesn't have the copyright? Can they make her have it removed? So Stacy, this is a great question with regard to the Kat Von D tattooing someone else's copyrighted work on something. Look, thankfully, like the Dave Matthews Band doesn't go after tattoo artists really for this kind of stuff because I have song lyrics that are their copyright tattooed literally on my wrist. There is a very big wave of fire dancer tattoos that is actually a drawing from Dave that is his copyrighted. It's getting towards concert season. I'll show you other people's tattoos, not mine, because I'm not. Yeah, so these are the Dave Matthews Band Fire Dancer. This is a drawing Dave did that has been recreated on tattoos, the Dave fandom world over. Oh my God, that one's stunning. Look at that with the watercolor behind it. Damn, it looks so good. Oh my God, this is fire. I need new tattoos. The Dave tattoo fandom is a whole and specific thing with the fire dancers. This fire dancer has been used by the band. It has been released by the band. Oh my God, that's so pretty too. Look at that arrow with the water. Damn it. We can't shop for tattoos, Emily. This is why we shouldn't Google. Anyway, the fire dancer image was drawn by hand by Dave. It has been recreated the world over by tattoo artists on people. Dave has allowed it to happen and hasn't gone after the tattoo artists because it's part of their community and love for the community. But I can also understand a photographer saying, what I didn't agree to was my photograph being directly recreated, but they cannot go and make the person who got the tattoo remove it. It's not that person's fault. It's the tattoo artist's fault. So she can be charged or really disengorged. It's like, well, how much did you charge to use this? And you have to license it. So pay me. Oh my God, this one's so pretty. Hold on. I've got to close this browser tab. Look at this with the watercolor. Look at that. It's so good. It's so good. Okay, I'm closing the tab. It's not pulling up. We're closing. It's so pretty with the watercolor. I'm so basic in my love for fire dancer tattoos. Do I have a fire dancer tattoo? Yep. Let's see. I think that's all the questions you got. Yeah, the tattoos are gorgeous. For sure. My hairdresser has a tattoo of Garth Brooks' sheet music. She was once in a room with him and he recognized it out of his peripheral vision. That's fucking amazing. And so it also involves chill. Like some people have chill about it. They want the Dave Matthews fandom community has a lot of Dave Matthews fandom tattoos. It's like the Disney community. There's tons of people running around with Disney tattoos, Mickey tattoos. Technically, those are copyrighted works. It's not fair use. However, it's whether it's going to be enforced or not. We should do a whole show on tattoos because there was a lawsuit over the recreation of the tattoo. Hold on. I'm going to pull it up so I don't get it wrong. We're Googling the shit out of stuff today. Let's Google it. Because my memory can't remember. Google helps me remember everything. From The Hangover. Then we will get back to it. So in The Hangover Part 2, they recreated a face tattoo from Mike Tyson. Is there a picture? No. But they didn't get permission from the tattoo artist who created Mike Tyson's face tattoo. So let's pull up Mike Tyson's face tattoo for all of you who aren't fans of the Hangover movies. I think they're very funny. So in the movie, there was a lot of gags with regard to Mike Tyson. And one of those gags ended up with the character getting the replica face tattoo. But the tattoo is the creation and the art of the tattoo artist. So when they recreated it on Ed Helms's face, I don't know why this is the picture that they used, probably so they wouldn't get shut down from using the still. But when they recreated the picture on Ed Helms's face, the tattoo artist said, no, I own the copyright in the tattoo that I fucking created for Mike Tyson's face. This was settled out of court so that the movie could be released, but it could have delayed the release of the film. So there are quite a lot of lawsuit related tattoos. So yes, the case continued. The Warner attorneys must have been concerned that Perry suggested she saw merit in the case. Oh, wait, was this before Judge Perry? Dude, Judge Perry is the bomb. Okay, we're going to pull that up case too. Judge Perry is really smart. I was sitting in on a hearing with Judge Perry with regard to the Hubbard case, the big YouTube Ryan's toy case that's going on in a class action. Judge Perry is fucking smart and really fucking smart. Okay, we're going to have to pull it up. Judge Perry would have been like, yeah, there is copyright in that. On May 24th, just days before the film was scheduled to be released in the U.S., District Court Judge Catherine Perry denied Whitmill's request for a preliminary injunction. Hangover 2 has since become the highest grossing R-rated comedy ever. I mean, as of the date of the writing of this, which would have been June 20th, 2011. The case continued. Warner's attorneys must have been concerned that Perry suggested she saw merit in the case, even referring to the studio's defenses as silly. In subsequent court filing, Warner said that it planned to digitally alter the tattoo for the home video version of the film if the case didn't settle quickly, and now it has. A notice of dismissal is expected to be filed. So they settled out of court and probably paid the tattoo artist for using the tattoo for a gag in the movie. So we're going to have to do a stream on copyrights and tattoos. That's just, I'm making a note. actually. Look, it feels like law school. We've got a notebook and Black's Law Dictionary and my beloved, this is a bookshelf. So you can, it's broken, but this is a bookshelf where you can I put my iPad on it. So when I read and highlight, I don't have to hold it. This came from the DA's office with me. It belonged to my mentor. And it is one of my favorite things. I was so happy when I found it. Because, we've been here a year and we're just not done unpacking yet. That's way more than you need to know about what's on my desk. But tattoo stream. That will be an episode of the Emily Show where we break down all of the things. You don't need my notebook in frame. What we don't need. All right, let's get to court of public opinion. Question. What is the line of such a bad image that it's no longer covered over copyright? What is the difference between intent and result? Oh, I have a whole thing talking about copyright and fair use with vidIQ, and it's in my playlist for the for creators here. But we do not have time to dive into the deeper connection of that. Brie Patrick, I definitely researched my two tattoos, Triforce and Deathly Hallows, before I got them because they're so simplistic, literally triangles, circles, and lines. They can't be copyrighted. Boom. Absolutely. Love the Triforce. Also love the Deathly Hallows. Deathly Hallows is on my list along with a lightsaber for future tattoos. Okay. Tattoos. You didn't miss Jen Shaw coverage, Caitlin. The Jay-Z case had new stuff come out and I knew that I wouldn't be able to get to it. I think I'm just going to record an Emily Show episode with Jen Shaw and get it released for y'all because it keeps getting bumped because that motion is long. We did a quick look at it and that is time-stamped from last week's Coffee and Cursey Words. But yes, it might get tabled till Friday or I might just re-record it. So yep. All right, let's get to court of public opinion. Let me pull up the Twitter without getting myself distracted on the Twitter because that happens all the time. And on Twitter, I forgot to include one of the options of no option. So we will get into that in a minute. Let me pull up my community tab. You guys, we're going to bing. So if you haven't subscribed, go ahead and subscribe. Don't forget to like the stream. We're getting close. Let's pull up community tab and get to the votes. Let's get to the votes. All right, let's get to the votes. Let's get to court of public opinion from Friday. Court of public opinion. All right, y'all. I'm trying to make this bigger. I forgot to put neither on Twitter, so I feel like I kind of invalidated the results. I'll put up another poll with neither on Twitter to give that option because with 8,000 votes, y'all are like, I've seen Rise of the Machines. I want nothing to do with it. I don't want a fully automatic home. I don't want a fully autonomous car. The machines are going to take over and I am not here for it. So neither. Don't fully automate anything. Sarah said, I will never have a fully autonomous house. Smart house traumatized me as a child with 10 replies and 70 thumbs up. So Sarah, everyone's like, yeah, exactly that. Rebecca said, I'd rather not have them due to the ability of getting hacked. This could mean lives at risk. It's a very, very fair point. So y'all highly skeptical. I appreciate you for that. Maybe we could do just some parts of fully like self-cleaning toilets and a few of the other house things that we don't want. But I get it. Having cameras in your homes that can be hacked into, and we've seen YouTubers talking about this when they've been digitally and cyber stalked and harassed about people hacking into their smart devices. It's going to continue to be a thing. Look, the rise of work in cybersecurity for these home devices is coming. So again, I'm sorry, Dave. I'm afraid I can't do that. Smart house ruined me forever having anything fully autonomous in the house. I get it. So did like Wall-E and Lazy Tommy Pumpkinhead. As Ian McCollum said, God help us, we're in the hands of engineers. Jurassic Park. Yep. You guys make excellent point. But a house that cleans itself, I mean, I feel like the robots in the house and like a self-cleaning toilet, and we could kind of knock that out and make it clean itself. I guess none of you have seen the movie Smart House. Can a smart house clean itself? Yes. Yes, it can. Yes, it can. So neither is what is won in the court of public opinion. I also had a typo in the one, so we'll do this. Fully autonomous car. I'm sorry, I make typos. The S and the A are next to each other. It happened. Y'all wanted a house, but in the comments, it was like neither things can be hacked. I don't like it. I've seen Smart House on Disney, and I've seen that episode of Eureka where AI turns you into a prisoner in your own home. I'm not doing it. So I love it. I've watched too many horror stories to feel comfortable answering. Neither. I've seen the second season of Death, Love, and Robots. Also, too many articles about Teslas running into other automobiles. Most of the Teslas running into other automobiles is because the drivers are idiots and they're not doing the thing they're supposed to do, because it's definitely not perfect yet. What you can't do is like sit in the passenger seat while your Tesla drives you home. Like that, you can't do that. The car needs a driver, because the car sometimes will get spooked, and I use it in self-driving mode. But if it gets spooked, it will pop out of self-driving mode and you take the wheel, but my hands are always on the wheel anyway with it. So I love my fully autonomous car. I think it would be cool to send the car back, but then all the cars have to be autonomous if you're going to be able to like send it back to your house and park. The future is among us. The future is among us for sure. Almost at 1,000 likes. Thank you. Have people not seen Outer Limits? The smart house is crazy. I take either, but because it impacts accessibility for disability. And I think there is room with that for sure. And there is room to have those conversations to make things more accessible. And I think self-driving cars can help make things accessible. I want Rosie from the Jetsons. I mean, right? I don't know. But also, like when you've seen the movies that have what is the Will Smith movie with the robots and they become self-aware? You're just like, damn it. Some of it's crazy and some of it's scary. We're living in the future, which is quite a lot of fun for me. You guys, thank you for spending Tuesday with me for Coffee and Cursey Words. It has been lovely. I appreciate you. Ashley Vincent, yes, there are episodes of Doctor Who where he gets trapped in the TARDIS. Yep. Thank you for being here. iRobot. Thank you, everybody. Yes, iRobot. Exactly. See, kind of traumatized from iRobot too. Sarah Myers, thank you for the super chat. I'm in the process of getting an Ariel tattoo with lots of artistic changes. If you finish it and share it on social, please tag me so I can see it. I would love to see your Ariel tattoos. I love tattoos. I want more tattoos. I wasn't sleeved because I was a DA, but it doesn't mean I won't be now. More tattoos, please. My husband's like, well, he doesn't watch this late in the stream, so he's not going to be like, oh God, no. More tattoos. We have plans for here. There will be more tattoos. Okay. That's a conversation for another day of the copyright law and tattoos and how they all play together. Thank you all for being with me for another wonderful Coffee and Cursey Words. I appreciate all of you. Thank you for being a Lawnerd. I will see you Friday night live, but maybe tomorrow. Follow me on social, sign up for the text crew, because depending on what happens with Brittany's court hearing tomorrow, if we need to talk about it, we're going to talk about it. We're just going to talk about it. So I will keep you posted on what's going on with Brittany. If you're not in the text crew, Twitter and Instagram at the Emily D. Baker, follow me there. I 90% of the time remember to post if I'm going to go live. No, I always share it out onto Twitter and to Instagram if I'm going to be going live with links so that you know. So follow me on social. I will keep you posted for Brittany's court hearing tomorrow. I'm fascinated. And that's it. That's it for Coffee and Cursey Words. I appreciate all of you for being here. Have a wonderful rest of your Tuesday, and I will see you soon. And I'll see you around the socials now. Have a good one. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.